A Supreme Court decision quietly rewired how gun laws live or die in American courts. Not one decision, not one change. 5 major battlegrounds completely transformed while gun owners scrolled past thinking nothing had changed. The biggest shift in Second Amendment litigation in decades happened right under your nose, and if you don't understand what just happened, you're walking straight into legal traps that could turn you from a law-abiding citizen into a defendant facing felony charges for doing exactly what you thought was legal. This is how the Supreme Court changed gun law without most gun owners even noticing, and why that ignorance could cost you everything. Before I show you exactly how this affects your daily life as a gun owner, I need to know, are you subscribed? Because what I'm about to reveal could be the difference between trusting the wrong headline and ending up in handcuffs. Hit that subscribe button right now, smash the like button, and drop a comment telling me if you've noticed these changes in your state, because this channel is the only place giving you the unfiltered legal reality that could save your freedom. Here's what just happened and why it matters to you in ways you haven't considered. For the last few years, most gun owners thought the big story was about carry permits or assault weapon bans or whatever new regulatory nightmare the ATF dreamed up this week. And yes, those fights are massive. But the bigger story, the one that actually controls whether you win or lose every single one of those fights, is something most people scroll right past because it sounds boring as hell. The Supreme Court changed the rulebook for how judges decide gun cases. Not just one case, the entire framework. The decision that started this earthquake was New York State Rifle and Pistol Association versus Bruen. And if you think Bruen was just about carry permits in New York, you missed the entire point. Bruen said you can't make regular people prove a special reason to carry a handgun in public. New York had this system where you had to show proper cause, which basically meant, tell us why you need to carry, and we'll decide if your reason is good enough. The Supreme Court said no. The Second Amendment covers carrying in public for self-defense, period. But here's the part that nobody is talking about, the part that's creating legal chaos in courtrooms across America right here in 2026. Bruen didn't only change carry permits. It changed how almost every gun law gets tested in court. Before Bruen, many courts used what they called a two-step approach. Step 1, does the Second Amendment even apply to this situation? Step 2, if it does apply, the judge weighs the law against the government's reasons, things like public safety, crime prevention, whatever justification the state wants to throw out there. It was a balancing test. Your rights on one side, the government's interests on the other, and judges got to play Solomon and decide which one mattered more. The Supreme Court basically told courts to stop doing that balancing act the way they had been doing it. Instead, Bruen told courts to focus on text, history, and tradition. In plain English, the government has to show that a modern gun law fits with America's historical tradition of gun regulation. That doesn't mean there has to be an identical law from 1791, but it does mean the government needs real historical examples that are similar enough in purpose and burden to justify the modern rule. Now that sounds academic. It sounds like something you'd only care about if you're a lawyer or a law professor or someone who gets excited about footnotes in Supreme Court opinions. But it has a very real effect on your day-to-day life as a gun owner, especially if you carry, if you travel across state lines, if you build firearms, if you buy parts online, or if you just want to avoid becoming a test case in someone else's legal battle. The first massive change that almost nobody noticed is this. Public carry permits flipped nationwide, but the trap just moved to a different location. Bruen's headline was about New York, but Bruen's impact spread across the entire country like a shockwave. Any state with a may-issue system where government officials could deny you a carry permit even if you passed the background check and met all the requirements got put on immediate legal notice. Those systems became legally toxic overnight, so a lot of states changed fast. Gun owners celebrated. They thought we won. We fixed carry permits. We can finally exercise our rights. But here's where people got fooled, and here's where you need to pay very close attention because this is the trap that's still active right now in 2026. Some states didn't just give up and accept constitutional carry, they adjusted their strategy. Instead of saying, you must prove proper cause to get a permit, they started saying, fine, you can apply for a permit like everyone else, but we're going to create giant lists of places where you can't actually carry that gun. These are called sensitive places. Places the state argues are so sensitive that guns can be banned there even if you have a valid permit. And yes, the Supreme Court acknowledged in Bruen that there are some legitimate sensitive places where gun bans can be allowed. Schools, government buildings, courthouses. That concept isn't new. The problem is what happened after Bruen. Some states took that narrow concept and stretched it until it became a new version of May issue, just wearing a different outfit. So here's what changed for you, the gun owner trying to follow the law. If you live in a state that responded to Bruen with massive new lists of restricted locations, you might have a carry permit in your wallet and still be walking into felony territory if you step into the wrong building without even realizing it. Imagine you're doing completely normal errands on a Saturday. You stop for gas, you grab coffee, you run into a pharmacy to pick up a prescription, you go to your kid's school for a quick pickup, you swing by the post office to mail a package, you meet a friend at a restaurant for lunch. In your mind, you're thinking, I'm legal. I have my permit, I passed the background check, I took the training class, I'm doing everything right. But post-Bruen, in some states, the problem isn't whether you have the permit. The problem is the invisible map of where you're allowed to carry, and that map can feel totally random to normal people who aren't lawyers. It can be nearly impossible to tell when you're crossing from a legal area into a restricted area, especially when you're inside a building that has multiple uses or multiple tenants. Here's a scenario you need to picture because this is happening to real people right now. You're in a shopping center, one building, multiple businesses, there's a private doctor's office, there's a small government service desk for vehicle registration or something similar, there's a daycare, there's a bank, there's a coffee shop, there's a restaurant, there's a pharmacy, all in the same shared structure, same parking lot, sometimes connected by interior hallways. Now ask yourself honestly, would you always know which specific part of that building is legally restricted and which part is not in your state at this exact moment in time? Under the newest rules that might have changed 6 months ago, most people wouldn't have a clue. And that's exactly why the Bruen fixed carry permits mindset is a dangerous mistake. Bruen changed the battlefield. It forced states to change their laws, but it also pushed some states to use a completely different playbook, one that's designed to make compliance nearly impossible for normal people. So that's the first gun law change that almost nobody noticed. It's not just about who gets a permit anymore. It's about where your permit actually works and whether you can even figure that out before you accidentally commit a felony. The second massive change is this. Domestic violence restraining order gun bans did not collapse after Bruen, and the Rahimi decision fundamentally changed how the history test actually works in practice. This is the part that shocked a lot of gun rights advocates who expected Bruen to steamroll every gun restriction in America. After Bruen came down, some lower courts started questioning long-standing gun restrictions, trying to apply this new text, history, and tradition test. One of the biggest fights was about a federal law that blocks gun possession for people under certain domestic violence restraining orders. The simple version is this. If a court has issued a qualifying restraining order against you that includes specific findings connected to threats or violence, federal law can ban you from possessing guns during the duration of that order. Then the Supreme Court decided United States versus Rahimi, and gun rights advocates lost their minds. In Rahimi, the Supreme Court upheld that federal law against a Second Amendment challenge. The court's message was basically this. Our historical tradition of firearm regulation allows the government to temporarily disarm people who a court has found to be a credible threat to someone else's physical safety. Now, why does that matter to you even if you're not involved in anything like a domestic violence situation? Because Rahimi is the Supreme Court explaining how Bruen's history and tradition test actually works in real life, and it's not what a lot of people thought it would be. A lot of gun owners heard history and tradition and assumed it meant this. If you can't find the exact same law from 1791 or 1868, then the modern law is automatically unconstitutional. Game over, government loses. Rahimi says it's not that simple. Rahimi shows the Supreme Court is willing to accept what they call historical analogies. That means older laws that are not identical to the modern restriction, but are similar enough in purpose and in how they operate. The court compared the modern domestic violence restriction to historical laws that focused on people who were seen as threats to public safety, including old surety laws where dangerous people had to post bond, and going armed laws that restricted certain people from carrying weapons in public. Here's the massive shift that gun owners need to understand. Bruen made people think the entire legal game is about the object, the gun itself, what type of gun, what features it has. Rahimi shows the game is also about the person and the risk they pose. The government can sometimes restrict gun rights if they can show a historical tradition of restricting dangerous people, not just dangerous objects. Now, I'm going to be extremely careful here because I don't want anybody misunderstanding what I'm saying. Rahimi does not mean that any law the government slaps a public safety label on will automatically survive a Second Amendment challenge. Not even close. What it means is that when a law is targeted at specific individuals tied to a judicial finding of dangerousness and limited in time and scope, the government has a much better chance of defending it using historical analogies. Here's a hypothetical example to make this crystal clear. Imagine two different laws. Law A says if a judge specifically finds that you are a credible threat to your spouse based on evidence presented in court, you lose gun possession rights for the duration of that court order. Law B says if you ever got any restraining order at any time in your life for any reason, you lose gun rights forever with no possibility of restoration. Those are not the same kind of burden on your rights. Law A is temporary, individualized, and tied to a specific judicial finding. Law B is permanent, broad, and disconnected from any current assessment of danger. Rahimi is much closer to Law A than Law B, and that distinction matters enormously. So, what's the practical takeaway for you as someone who cares about gun rights long-term? You have to start paying attention to how courts are dividing laws into different categories. The strongest Second Amendment cases, the ones most likely to win, are usually not the ones that rely purely on emotional outrage or political slogans. The strongest cases are the ones that clearly demonstrate the law is too broad, too permanent, too disconnected from actual danger, or too untethered from any real historical match. Courts are looking at whether the restriction is tailored or sweeping, temporary or permanent, individualized or categorical. If you've ever wondered why some gun laws survive even after Bruen while others get struck down, Rahimi is a huge part of the answer. It gives courts a framework to uphold certain restrictions while still claiming they're following Bruen's history and tradition test. And if you're finding this breakdown valuable, if you're starting to see how the legal landscape is way more complex and dangerous than the headlines suggest, then do this right now. Subscribe to this channel, hit that notification bell, drop a comment telling me what state you're in and whether you've seen these post-Bruen changes happening where you live, because I need to know you're paying attention to what actually matters instead of just consuming rage bait that doesn't help you stay legal. The third major change is this. Bump stocks changed gun law without even being a Second Amendment case, and that reality should scare you more than it comforts you. This is where most gun owners get completely confused because they assume every major gun ruling from the Supreme Court is about the Second Amendment and constitutional rights. Not true. Not even close. Garland versus Cargill, the bump stock case, was not primarily about whether bump stocks are protected by the Second Amendment. The big question was simpler and more technical. Did the federal government correctly treat bump stocks as machine guns under the specific statutory definition that Congress wrote decades ago? The Supreme Court said no. The court focused on the precise definition of machine gun in federal law. That definition covers weapons that fire more than one shot automatically by a single function of the trigger. The court said a semi-automatic rifle equipped with a bump stock does not meet that definition as written because the trigger is still being released and pulled again for each shot, even if it happens very quickly. Here's the most important part for you as a gun owner. The Supreme Court did not say bump stocks are good or useful or that people should own them. The court said if Congress wants them banned, Congress has to write a law that actually bans them clearly and specifically. A federal agency cannot stretch existing words until people become criminals for owning something that was legal yesterday. That sounds like a win for gun owners, and a lot of people celebrated it that way. But I want you to hear the warning that's buried underneath that decision, because the real risk to normal gun owners is not always a direct gun ban that gets debated in Congress and voted on. A lot of the real risk comes from how the government defines things. What counts as a firearm? What counts as a receiver? What counts as a machine gun? What counts as a silencer or suppressor? What counts as a short-barreled rifle? What counts as readily convertible to full auto? What counts as designed and intended for a particular purpose? Those definitions are where regular people get trapped and turned into accidental felons. Here's a scenario you should imagine because it's closer to real life than most people want to admit. You buy a product that is completely legal today. You keep your receipts. You follow all the rules you know about. You don't do anything shady or questionable. You're just a normal gun owner. Then a federal agency changes its interpretation of an existing regulation and announces we now believe this product fits into a banned category under our new reading of the law. You have 90 days to destroy it, surrender it, or register it, or you will face felony prosecution. Even if you personally hate bump stocks and would never own one, you should care deeply about this kind of case because it's about how quickly a regulatory interpretation change can turn normal ownership into a criminal issue overnight. Cargill is the Supreme Court sending a signal to federal agencies. You don't get to create new criminal rules by stretching old statutory words beyond their clear meaning. That matters for way more than just bump stocks. It affects how future rules about gun parts, accessories, frames, receivers, and product classifications get written and defended. And that brings us directly to the fourth major change. Ghost gun kits and unfinished frames got pulled deeper into federal control, and Bondi versus Vanderstock tells you the government has more regulatory room than many gun owners thought. If you only follow gun news through social media memes and short videos, you might think the Supreme Court always expands gun rights and always rules in favor of gun owners. Reality is far more complicated than that. In Bondi versus Vanderstock, the Supreme Court upheld a federal rule that treats certain weapon parts kits and unfinished frames or receivers as firearms under the Gun Control Act, at least in specific situations. That's a massive deal because it means the government can require things like serial numbers and regulated sales channels for certain kits that are designed and marketed to become functioning firearms. Notice what's happening here again. This is not mainly a Bruen-style Second Amendment case in the way people usually talk about gun rights. This is another case about statutory definitions and federal regulatory authority. And it changes the landscape quietly but powerfully because it directly affects builders, hobbyists, and people who buy build kits online. Here's what most people get wrong about this entire issue. They assume ghost gun means anything homemade is automatically illegal everywhere. That is not automatically true in all situations, and the specific details matter enormously. State laws differ widely. Federal rules differ depending on what the item actually is, how complete it is when sold, how it's marketed, and whether it comes with the parts and instructions to readily complete it into a functioning firearm. But the real-world impact for you is this. If you buy build kits, if you work with unfinished receivers, if you like buying parts and customizing firearms as a hobby, you need to watch this regulatory area like a hawk because this is where a massive number of people accidentally become criminals. Not because they're violent, not because they have bad intentions or criminal records, but because they didn't realize the legal classification of a product changed based on new agency interpretations or new court rulings. You bought something that was marketed as legal. You have it sitting in your garage or your workshop. Then the rules change, and now you're supposed to know about that change and comply within a deadline you might not even hear about unless you're actively following federal regulatory updates. That's the trap. That's how normal people become defendants. The fifth major change is this. Assault weapon bans and magazine capacity limits didn't get resolved by the Supreme Court, and that non-decision is a major change all by itself. This one is going to sound strange at first, but stay with me because this affects how you live your life as a gun owner right now in 2026. A lot of gun rights advocates expected Bruen to lead to a fast Supreme Court decision that would definitively settle the massive ongoing fights over state assault weapon bans and magazine capacity limits. That did not happen quickly. In fact, in some high-profile moments over the last few years, the Supreme Court actively declined to take up certain cases that would have forced them to rule on those exact issues. When the Supreme Court declines to grant review of a case, it does not mean they agree with the lower court's decision. It does not mean the lower court got it right. It often just means not this case, not right now. We're waiting for a better vehicle or better timing. Courts care about procedural timing, the quality of the factual record, and whether a specific case is the right vehicle to decide a huge national constitutional issue that will affect millions of people. But here's the part that almost no one notices or talks about. When the Supreme Court says not now and declines review, the lower court ruling usually stays in effect in that jurisdiction. That means if a federal appeals court upheld an assault weapon ban or a magazine limit and the Supreme Court doesn't take the case, that ban remains in place and enforceable in that state or that circuit. It also means other courts in other parts of the country can look at that ruling as persuasive guidance, even if it's not technically binding on them. So what actually changed here? The change is that gun law became dramatically more regional and confusing for longer periods of time. If you live in one state, you operate under one set of rules. You cross a state line and the rules completely flip. Your standard capacity magazine that's normal and legal at home becomes contraband the moment you cross into another state. And because the Supreme Court can move very slowly on these issues, that regional mismatch can last for years while cases work their way up through the system. Here's the real-world travel scenario you absolutely need to picture in your mind. You live in a state where standard 30-round magazines are common and completely legal. You have a range bag, you have gear you've owned for years. You decide to drive to visit family or attend a training class or go hunting in another state. You pack like you always do. You're not even thinking about the magazine in the side pocket of your bag or the spare mag in your vehicle's center console. Then you arrive in a state with a strict 10-round magazine limit. You get pulled over for a minor traffic issue, maybe a taillight out or slightly speeding. The officer asks questions. You answer honestly because you think you're being a responsible gun owner and you have nothing to hide. You mention you have firearms in the vehicle, and suddenly your normal, everyday property is being treated like contraband. You're being detained. Your vehicle is being searched. Your magazines are being counted and measured. And now you're facing criminal charges in a state where you don't live, where you don't know the local attorneys, where you might not even understand what you did wrong. This is where consequences get real fast. Even if you eventually beat the case later, the process itself can be the punishment. Lawyer fees running into thousands or tens of thousands of dollars. Lost time from work, job complications if you have any kind of security clearance or professional license, firearm seizures that might take months or years to get back if you get them back at all. The stress and anxiety of being criminally charged when you thought you were following the law. You don't want that. Nobody wants that. And here's a second scenario that's also extremely real for modern life. You're a concealed carrier. You travel for work or personal reasons. You walk into what you assume is a normal public place, a shopping mall, a restaurant, a medical building, a sports venue. Depending on your state and depending on the newest post-Bruen rules that might have been passed in the last year or two, that location could be classified as a restricted, sensitive place. Or it could be a location where the default rule has been flipped. Instead of the old system where you could carry unless the property owner posted a sign prohibiting it, some states tried to flip it after Bruen to you cannot carry unless the property owner posted a sign explicitly allowing it. That's a complete reversal. It turns everyday life into a giant guessing game where you're supposed to know the legal status of every single building you enter. And the Supreme Court's slow pace on deciding these big ban cases matters enormously, because while the legal fight is still playing out in courtrooms, you are the one living under the current rules right now. You're the one at risk of arrest and prosecution if you guess wrong. So yes, the Supreme Court not deciding the major assault weapon ban and magazine limit cases yet is itself a massive change. It means the legal uncertainty continues. It means the rules stay fractured across different states and different regions. It means your legal risk depends entirely on where you physically are at any given moment. Now let's get brutally practical about what you need to do with all of this information, because knowing what happened is useless if you don't change your behavior based on that knowledge. First, stop trusting single-sentence headlines. Stop trusting social media posts. Stop trusting what your buddy said he heard at the gun range. If you see a headline like Supreme Court upholds gun law or Supreme Court strikes down gun law, your immediate next question should be, was this a Second Amendment constitutional rights case? Or was this a statutory interpretation case? Or was this an agency authority case? Cargill and Vanderstock are perfect examples of why that distinction matters enormously. They affect your real-world risk and your real-world legal exposure, even when they're not framed as classic Second Amendment constitutional battles. The legal category of the case determines what it actually means for you. Second, you need to understand that Bruen is an engine that's still running, not a finish line that's already been crossed. Bruen created the text, history, and tradition test. That test is going to keep producing new court decisions and new legal results for years, probably for decades. Courts at every level are going to keep comparing modern gun laws to historical patterns of regulation. That means new carry rules, new sensitive location bans, new training requirements, new insurance requirements, and new permit conditions are all going to keep getting challenged and tested in court under the Bruen framework. Subscribe to this channel because I put in the hours reading court opinions and tracking regulatory changes so you don't have to. I'm not here to sell you comfortable lies. I'm here to give you the information you need to stay legal and stay free. And one final note before we end, I am not your lawyer. Nothing in this video is legal advice for your specific situation. Laws vary dramatically by state, and your individual circumstances matter. If you need guidance for your exact situation, talk to a qualified attorney licensed in your state who practices in this area of law. But until then, stay informed, stay vigilant, and never stop fighting for your rights.